I don't want to say that's not really true. That's not my opinion. It's not that it's pro-labor. It's pro-employee.
Well, and on the subject of just cause decisions, I mean, that road's been traveled a million times. I mean, I don't think an arbitrator has a whole lot of leeway to dispute facts that are put in front of them.
I think they have a ton of flexibility in interpreting, because when you look at the ability to challenge the outcome of an arbitrator's ruling under Florida law, it's extremely limited. So, and the arbitrators know that.
Decision is a whole different thing. When we have a contract provision that says an arbitrator's decision is final and binding, and then the next thing you know, well, we'll go on to district court. Well, why is that? Because we disagree with the arbitrator. Well, don't we have a clause that says that it's final? Yeah, but you know, he was outside of the scope of his authority, and he ruled on something he shouldn't have been. Come on, man. We have an arbitration process to keep us out of court. If every single time we get a decision we don't like, we end up in court, the whole thing's a waste of time. Might as well just go to court for everything. And I, for one, as much as I just got to swallow a whole lot of pride, will accept an arbitrator's decision that I thought was slanted 110% against the union, and I've had those cases before. But you know what? You live by it. You know, the arbitrator was mutually selected out of a panel. We both struck a bunch of names that end up with the final guy or gal, and what they come up with is what they come up with, and that's, you know, like I said, I've had Thompson, Sizemore, and Gonzalez. I don't know if you know that law firm.
Very well, sure.
You know, I've had Tom Gonzalez challenge a decision of an arbitrator, and I've had that same discussion with him, and it was over a contract language. It wasn't even a disciplinary matter. And lo and behold, he's got to go to court, you know, so our attorney represents him in court. The judge told him the same thing the arbitrator told him. It was a whole waste of his client's money and time. And that was the only one case that I've had to deal with an employer wanting to go to court because they disagreed with an arbitration decision. And I just hope that that doesn't happen here. Out of all the you know, grievances and employers I've dealt with, it's only happened once in 6 years. But yeah, and then it makes you wonder, you know, is this law firm just trying to squeeze every last cent they can out of their client? You know, it makes you wonder, you know. And that particular employer, the attorney was at every single grievance hearing. Step one grievance hearing, they have a $350 an attorney sitting there. Blows my mind. It's like, waste your money. I told the CEO of the company, you are wasting your money having this guy sitting here. And of course, that didn't go over too well. But anyway, I just want to have.
That must have been a private sector case, $350 an hour. Yeah. That's not the going rate in government. So.
Maybe you're in the wrong business.
You get a three
Pasco
attorneys.
Pasco gets a 2-for-1 deal,
yeah.
right?
Yeah. Well, I think Global Love Sponge picked that same law firm for a reason. But anyway, the point I'm trying to make is that we're not trying to do anything that's outside of the ordinary. I think we spent hours and hours and hours and hours talking about something that I've negotiated contracts. That's one of the first things that's just signed off on. Yeah, just cause for discipline, we get it, union. Here's your arbitration procedure. Now let's talk about wages. And we spend all the time talking about money. I've never had to have this long, drawn-out dispute over what is the most fundamental, basic provision and all the CBAs that we have.
It's the provision of the contract that puts the union and management in an adversarial position several times a year. So it's a very important article, and it's to us not one that should it's just not, you know, boilerplate language to sign off on it. It could be improved greatly, the process, to make sure that it's fair to the employee. You know, that's objective number one. It should be fair to the employee. That it's the process can operate quickly, so it doesn't linger and spread throughout a department when it could be dealt with quickly, and that it's cost effective. And that's our three objectives. Our first objective is the same as your first objective: fairness to the employee, that the employee gets a fair shake, and that there's a way to look into that, and it's transparent.
Okay, but what could be more fair to an employee to pull in a neutral outsider to make a decision than to have county appointees make a decision. I mean, I can't get past your first objective. What's fairness? What's fair to the employee?
I don't agree that bringing in a third party that knows nothing about the operations of the county or the employee, is that great a deal?
Well, having a just cause provision doesn't. I mean, I understand that some of the processes of the county will bleed over into what's considered just and unjust, but again, that road's, like I said before, it's been traveled a million times. So when an arbitrator is, I had one arbitrator that graduated from Cornell University in 1948. That guy's been around some time. And so I think he's pretty much seen and heard every possible thing that you could imagine with respect to a just cause case.
That's the kind of arbitrator that's done listening, 2 minutes into the arbitration.
No.
And that's what we don't like.
Actually, that arbitrator voted against a case I had, but it's a discharge case. So, but what you just said isn't necessarily, if that were the case, I guess he was done listening after the employer spoke and not after the union spoke.
It's not good either.
Right, but I think that case, I mean, again, I take my lumps and move on. I learned why I understood why he made the decision he did. I get it.
But you don't agree with it.
Don't necessarily agree with it, but I understand the mindset.
Yeah, but you didn't agree with it, obviously, because you got to the point that you needed an arbitrator. The arbitrator ruled against you. So,
I accept it.
So what good did that do the employee?
Because
there's got to be a different process that would get the employee.
Because I can tell the employee, listen, the union believed in you. The union believed in your case. The union spent the money needed to get an independent opinion. And this very intelligent person came in to listen to the case, and he decided against you. And I can say that face to face. I don't have to tell him that, well, this personnel board voted against you. Well, John, who's on the personnel board? Well, they're appointees. Appointees of who? County commissioners. Well, don't you think that maybe they're not giving me a fair shake because they all have some kind of connection with my employer? And how am I supposed to answer that? Any more than if we said, listen, we're going to take this case to the union's executive board. Well, who's on the union executive board? Well, Ken Wood. They were elected. That's even better. They were all elected. So how fair would you feel that we took this discharge matter and brought it to the local union's executive board to get a majority vote on it? You'd be like, sorry, dude, that's kind of slanted, don't you think? I mean, that's the way we feel. It's slanted.
Okay.
I think that hit the nail right on the head. Right there. Yeah.
All right. Let's stop on one of John's high points and take a break for a couple minutes.
One of my high points are all high points.
Put your head
Every word out of my mouth is a
There's
high
another
point.
comfortable chair.
Yeah.
And we've been recording, but I didn't because I came in late, so I'll just pick it up at this point. You're recording, right?
Yes, sir.
Okay. So if we needed it, we could get it.
Okay, they're having you go there and watch it. Okay. All right, brother, thanks a lot.
Well, do you want to back up to, so Barbara was hearing our discussion on management rights and monetary benefits. Are we just going to move forward, or
Well, the monetary benefits, that's Article 5. That's Doreen's typing it up the way we discussed, so we can pay it on that one.
Let me just make a note here where I'm recording, and I did not record the first part of the bargaining session. I came late to it, so it's 11:15. This is a bargaining session between Pasco County and Teamsters. All right, so 5, we have a TA on with language change, adding a D and deleting the last paragraph. It's being typed. We'll sign it before we leave today.
okay. What about management rights?
Management rights, if you go to the second paragraph, I think you are in agreement that there would be a period after the word subcontract. And we are in agreement to add the following language, a new sentence after that. Correspondingly, the union has the right to request impact bargaining of a decision to subcontract bargaining unit work.
That's fine.
Okay. So we'll type up that one too, before we leave today. That part of it. Now, I think we're still in disagreement on the last paragraph, correct?
Last
But
paragraph
wait,
of
see,
what?
you're looking at management rights.
I thought we were just talking about management rights.
Oh, I thought you had moved ahead.
No.
Okay. To bargaining unit work.
Yeah, no, management rights was.
The point about the subcontracting.
Yeah, that's in
Yeah, but I thought.
10. That's not in management rights.
Well, the thing is, if you recall, our last bargaining session, I said, why are we talking about subcontracting? Or, I'm sorry, why are we talking about management rights and bargaining unit work? Why don't we talk about that in management rights? So then we hit rewind, and then we wrote a sentence. You proposed a sentence that the county's management rights to subcontract came at the tail end of Article
Yeah,
4.
the language is, I'm working from the language that's in 10 right now. If you go to our proposed 10, it's that second paragraph.
Okay, so this is
All
going
right,
to be
and
taken
then-
from 10 and put back into 4?
We could, if that's what you like, that's fine. We don't care where it is. And then that would also include the language regarding the union's right, even though oddly enough, that would then be in the management rights article.
Yeah, I prefer to have references of management rights under the heading of management rights. I just think it makes more sense to me. I understand why it's in bargaining unit work, but since the subject of it is a management right, so.
All right, well, I don't really have a problem with tagging on what the union's right is in there.
Ren,
If you want that other provision somewhere else in the contract, just tell us where you want to put it.
yeah.
Well, I mean, do you recall adding that sentence to the end of management rights the last time we were voting?
Yeah, but if I'm pointing out that it's in 10, so it would come out of 10.
The reason we
Shift
put it in
over to
4 is
4.
because last time when we were bargaining, we had gotten to 10.
John, we're all right with that,
Okay.
all right? You asked to add additional language. When I wasn't here, you said that your attorney thinks there should be a comment about impact bargaining. We're prepared to add that.
I understand that.
So do you want to add it at the end of what we're adding to management rights? Or do you want to add it somewhere else in the contract?
I'm interested in deleting the language in Article 10 and putting whatever reference there is to subcontracting and management rights into 4. And so let's just talk, if that's okay. If you're fine with deleting this from 10, moving the whole provision on that subject into 4, that's what I prefer to do.
We're talking about the second paragraph, right?
Second paragraph of 10,
Oh,
correct?
10, yeah, that's fine.
Yeah, the underlined new language that's been added.
That's right.
All right, so with that being said, let's go back to 4 and let's get it now.
Okay. Didn't we just do that? We're just going to move the language over there.
Yeah, well, we were in the middle of doing it, and Barbara said, why are you looking at 4, John, when we're talking about 10? So,
Yeah.
let's fix 4. Nothing in this agreement shall be construed as a waiver or limitation on the county's management rights to subcontract all or part of work performed by bargaining unit employees. Correspondingly, what's the language say correspondingly?
Correspondingly, the union has the right to request impact bargaining over a decision to subcontract bargaining unit work.
Okay, well, let's get that typed up and let's call it 4. And we're going to strike that from 10. Right?
That's right.
All right, so,
But we're still not ready to sign off on 10 because we have that other issue.
well, I understand that, but I mean, going in numerical order, at least we have 4.
Okay, so, just this, and then, we need that one, which, want to put that. Put that.
Leave that in.
Why don't we just type it up in hand with the keyboard?
Okay, and give her Article 4 too. 4. Then take Article 4 and then add that and correspondingly.
4.
Yeah, just get rid of 4.
Here, let's see. Take it from here.
Does she come in with one that we can sign yet or no?
I changed a little grammatical thing.
Okay, where are we? 10?
Yeah. Our position on Article 9, I told Barbara before you got here that, we're still holding the union dues deduction article. If we get everything else right, then we're not going to let that hold up for the time being. We're holding it in abeyance. So 10, I think you walked in and tail end of our conversation about I don't know, maybe it was before you got here.
It was.
About
Yeah, he came in.
reducing the overtime. And we were explaining that the county has a lot of room or a lot of latitude with being able to address certain situations that you have a need to have non-bargaining unit employees perform bargaining unit work. When there's a work backload or delay, when there's a temporary reduction of the workforce, when there's an emergency situation, when you're instructing or training people, and when there is a county emergency or weather event, a weather emergency event. Those are a lot of different situations that you can have some non-bargaining unit employees perform bargaining unit work. We just do not agree with the concept that just for the sole purpose of reducing or avoiding overtime, in absence of any of those other situations, that you should have a right to fulfill, to have that work performed.
Would you agree that any one of these other triggers could have an effect on overtime, but it wouldn't be actionable, right?
Absolutely. In fact, that was what we were saying, that most of those other situations are going to create, because if you didn't use non-bargaining, that you probably would run into overtime. So, and that's part of our point, that all those other scenarios are, are to avoid overtime. So, but to have no reason other than just, for the sake of, I do not want to have any overtime when there is no emergency, when there is no backload, there is no delay, all those things. That's what we disagree with. So I think you got what you need, to do the job, and get it done.
Well, we got what we need, except for the standalone ability to reduce overtime by using a non-bargaining unit employee, which is an important fiscal tool for us to keep.
But why would you have an overtime event? What causes overtime to do work?
Could be absenteeism, vacation schedules, personal time taken in association with a holiday, any number of reasons.
But those scenarios, you should have staffing levels to compensate for for those type of scenarios. I mean, you have a guy that's going on vacation. I mean, the employer's in control of scheduling vacations. I'm sure that if out of a 12-person work group, all 12 of them wanted to take the week of 4th of July off, you'd have to prioritize and say you can't all take it. The work still has to be done. So you being the county, has the ability to schedule vacations to
But John, staffing's a very lean level at this particular point. It may have been the case in the past where we could shift people around a little bit, but there's no extra people to shift around at this point. It makes no sense to call somebody back or keep them on overtime when somebody can do the same work on a limited basis, not often, for less money than the overtime money, maybe more than the hourly rate of the employee that usually does it. But would you agree to our language if we were to put some type of cap on it?
I just honestly believe that if you have too many people on vacation, or you got 2 guys on vacation and 2 other people call out sick, what is going to be your need to fill, to have non-bargaining, perform bargaining? Because why? Because there's a work backload?
There could be.
There's a delay?
There could be some event that occurred that requires more personnel to perform it. There's any number of combinations. We're just looking for a tool to control the overrun of overtime.
Well, Barbara mentioned that.
You're approaching it as though there is, some type of stealth guarantee of overtime, and there's not.
So I was just going to say that before you cut me off, that Barbara thinks that we believe we have an inherent right to work overtime, and that's not our position.
Barbara and I believe the same thing.
We don't. We do not have an inherent right to work overtime. However, if a guy is doing a job and we have a bargaining unit that's been painstakingly defined by PERC, that the people that are in the bargaining unit are the ones who are supposed to be performing the bargaining unit work, because once you take those walls down, then there's no concept of a bargaining unit anymore. That if you have a need to work overtime, it's just only the polite thing to do is to offer to the people who work there. It's the righteous thing to do. But understanding that there are some circumstances that it's just going to blow up the budget. But what we want to get away from, and I wish we didn't have to repeat all this stuff all over again. We just spent a half hour talking about it with Barbara.
Well, we don't have to talk about it again.
But I want you to hear some of these things, though, because if a new administrator comes in, and because Barbara made a comment that there's more or less 2,000 employees that work for the county, and someone can come in and say that, we just believe this county's top heavy. We just believe, not top heavy, but too many people working here. So we want to cut that down. Or we can run a leaner crew and start utilizing some of these people that are on salary a little bit more often to fill in the gaps. And we don't know what the trend is going to be. The way this is worded, to reduce or to avoid overtime, and that standalone clause or section of the clause, that you have the ability to invoke that just for no other reason, that we do not want to pay anybody overtime, or we want to reduce it, that we have a right to in other words, a guy works an hour or 2 hours late, and on a Monday, does it again on Tuesday, and so on Friday he's going to be probably flexing out some of his time, but the work still needs to be performed. It's just not fair. You send the guy home, and then you have a management person or a temp do the same job that he was doing. It's just good.
Okay. Jim, I kind of spoke with Barbara, gave her a scenario earlier, and I'll kind of modify it a little bit. In utilities, whether it be water or wastewater, we have either a water main that carries potable, drinkable water, or a force main, what we call a force main that carries raw wastewater. In the case that one of those should break, and it should be a big job that maybe blows out a road, we've had this happen, what we do is, even though we have people in water maintenance that from day to day they only work with potable water, we can call on that pool of employees where it's hypothetically myself and sewer, we would have to be short because we had vacation people, we had some people out on sick leave. we would be able to pull from the other pool of water people to help out. This is what we do in actuality. From day to day, this can happen. And what we're trying to get away from here is saying, well, sure, we got these water guys to come in who are in the bargaining unit. They could come in, but instead we'll leave them at home and we'll bring somebody else in, non-bargaining in whatever facet, to fulfill these positions. So that's, I think, was what we're trying to avoid, is that being able to happen. When we truly have bargaining unit people that can do the job, that are available. And like I say, when it really comes down, we do have day-to-day operations issues where we have people on vacation, where the crew is not a complete crew as it normally would be. We have the other staffing amongst the maintenance in a whole that we can pull in those people, and we would just like the right to be able to pull those individuals in versus saying, well, they're not technically in sewer and we got 2 guys also, we have to pull these other people that are outside of the bargaining in to complete that job.
Well, also with your scenario, Warren, is basically what they want to do is you work that main break from 7:30 to 5:30. 5:30, you guys go home and the supervisors finish the main break.
Yeah.
That's what they're talking about.
Yeah. And it's not necessary. We do have the people. If you bring everybody in as a group to focus on one problem, there is enough people. There should never be a reason why we should need to bring a non-bargaining unit people to fulfill what would normally be a bargaining unit's job.
Well, we have a very good reason for wanting to do that, and it's called fiscal responsibility. If the task could be accomplished in the same manner for the benefit of the public, for less money, that's what the county should be doing.
Yeah, we got something to say before we move on.
Yeah, we have supervisors that drive a couple, 3 times a week, 4 hours each. They gotta do door to door, we don't have enough drivers. We don't wanna cab them out.
Well, the scenario I was explaining to Barbara was, you have an employee that's making $10 an hour, has to decide on whether to get his family insurance or put food on the table. Gets a little bone every so often for overtime. He gets sent home, you bring in the $30 an hour supervisor whose his only decision is what dinner or what restaurant him and his wife are going to for dinner and what movie he's going to see. Big difference. Don't you think you owe your employees a little respect? As an employer, don't you owe your employees, I know you owe the public, but as an employer, don't you also have a responsibility to your employees?
Yeah, I think our language finds the proper balance between.
It doesn't. It says you can send your hourly employees home and bring in the supervisors.
Look, it says we may, number one. It doesn't say we shall or will. It says we may, and it says temporarily perform. So, and I've already offered,
Well,
I already asked the question whether or not you'd be amenable, or maybe the solution to the dispute is to put some kind of cap on that.
What would be
I just got my 25-year clock the other day, and I know what May means for Pasco County. Okay? I've seen Pasco County's May.
Okay. So I guess we're done on talking about
Well, what is your, just get it out, what is your proposal of an hourly cap?
I threw it out to you. I have no idea. I'd have to look at what the numbers are on it and see if it would be efficient. But, you know, in the same manner that, you know, there can be limitations on a right, this would be a limitation on a right. Trying to find a point of compromise on the clause to reduce or avoid overtime.
I'm in favor of a cap, and I'm not shy of saying this in front of everybody, I'm in favor of a cap because it's going to apply to everything, not just that one specific part of it. I mean, that's what you're talking about, right?
I'm talking about a cap on the clause to reduce or avoid overtime.
Okay, but if there's, to reduce, I mean, we've already established that when there's a work backload or delay, or there's a temporary reduction in the workforce, or if there's an emergency situation, or if there's training, that all of those scenarios would create overtime if you didn't have the ability to have non-bargaining perform that work. So it's all related to overtime. I mean, every one of those things is I mean, this whole article is about, you know, what you call fiscal responsibility and what we call kind of skirting around paying the bargaining unit employees or hire more of them. I mean, you know, that's the reason why we don't believe we have an inherent right to overtime. We just believe we have an inherent right to the work. the work that we organize the workers to perform. And so when you are short-staffed and understaffed, and you want to say that, well, you don't have a right to that overtime, well, you should be doing the right thing and hiring enough people to perform the work, because otherwise it starts becoming a shift into undermining, the whole concept of having a bargaining unit. And I know you say temporarily, this is only about a temporary scenario. So when you're talking about an overtime cap, because all of this relates to overtime, in my opinion, I guess what we're defining what temporarily means.
Well, John, I don't agree with you that you have an inherent right to the work. You have the inherent right to negotiate wages, benefits, and conditions of employment.
Me
for your
personally,
bargaining
me as a
members.
representative for a local
Right.
unit, correct.
Yeah.
But the employees have an inherent right to the work that they're performing. That's okay, we disagree
Yeah,
on that, that's fine.
to the work that they're performing that we don't otherwise find a way to do with somebody else. That's true. I agree with that. And I think that 99% of the time, we have no issue or dispute. We're talking about 1% of the time probably here that's in play that we're arguing about. And that's the flexibility that we're looking for.
I think
If you want us to come back and quantify that for you and tell you that,
I just
we
think
think
that
it's worth X number of dollars or X number of hours per year in overtime, we could probably do that.
I just think that, and from a bargaining standpoint, we've moved tremendously from a very hard line approach of, only bargaining unit work can be performed by non-bargaining employees in a very limited 3 conditions. We've opened up to meet your needs of flexibility. And I don't think we're being unreasonable to say that there's very limited money to be had in the way of raises. I mean, your position is that you don't want to give us raises. Our position is we need to get a raise. We need to get a 5% increase instead of even making up for what's been taken from what we've earned. But this is another, another way for the county to take dollars out of someone's pocket. And it's like, if you want to reduce the workforce and shrink it down by taking, laying off employees or moving them around, that's fine. But, I think if you paid an hour of overtime or 2 hours of overtime to a few employees, it's a heck of a lot cheaper than hiring the staffing levels that you probably need to do the job. You're still saving money in the long run, but it's just like it's going too far when you don't have adequate staffing, and then you're telling everybody that you can't work any overtime, and then I'm going to send you home early. I'm going to have someone else come behind you that's not even in bargaining units to do your work. It's just that's where we just draw the line where it's just overkill.
Okay.
I just think you got the bases covered. You gave a scenario. I want to keep talking about this a little bit. You gave a scenario that you have vacation scheduling, or you have absenteeism issues. I've already said once in bargaining that if you have a mass call out, if you have a bunch of people that are, it's the day after Super Bowl Monday or whatever the day is, and a huge group of employees call out, that you could use this language that you have a work backload or delay, or you can even morph it into we have an emergency situation. We have to get this work done, and you have that flexibility to do that, but you don't have to just isolate for no other reason than to reduce the void over time. And I guess that's it on that. What about this last sentence about deleting the verbiage and putting in there when the county emergency operations center is activated? Are we okay with